Welcome everybody, and welcome to the first in the series of contract conversations. This series of bi-weekly webinars being hosted by lawyers from across Mills and Reeve to discuss key contractual issues which people operating English law contracts need to be aware of. The first in the series today concerns what issues will arise out of Brexit. I'm Mark Davison, Head of International Arbitration here at Mills and Reeve, based in our London office. I'm joined today by Eric France.
Hi, I'm Eric France, Commercial Disputes Partner at Mills and Reeve, also based in our London office.
So I think, as we all know, the UK left the EU on the 31st of January 2020. The true impact of Brexit has much been minimised due to the transitional arrangements that we have in place with the EU until the 31st of December 2020, which has largely maintained the status quo. However, contractual drafters need to be aware and need to address the issues which Brexit causes, regardless of whether the transitional period is extended past the 31st of December 2020 or not. There's obviously been much discussion over the last couple of days about the Internal Markets Bill and its impact on the EU withdrawal agreement. We're not going to touch on that today, but we'll aim to do so later on in the series, especially once provisions regarding the non-discrimination of trade across the UK has been resolved, and we know how that will operate. But today, Eric and I are going to focus on 8 key issues which may affect English law contracts post-Brexit and the end of the transitional arrangement. Obviously, there are other issues which arise other than these 8, but we focused on these 8 as these are likely to be the key ones which are relevant to most parties. There is a Q&A function at the bottom of the Zoom screen, so please feel free to ask questions and we'll try and address those at the end. So Eric, do you want to address the first issue about governing law?
Okay, the first issue is what law is going to govern your contract after the transition period ends. It's the governing law of the contract that sets out the rules of how your contract is going to be interpreted, and it also defines what remedies you're entitled to if the other side breaches the contract. The good news is that we don't expect Brexit to have much impact at all on the rules for determining the governing law of a contract. Those rules are set out in an EU treaty called Rome I, and member states that remain within the European Union will continue to be bound by that treaty. The UK is no longer bound by Rome I, but it has incorporated the substance of the rules in Rome I into English law through UK legislation. So the rules in Rome I will continue to apply both here and in the EU, even after the transition period ends. So the Rome I rules deal with the situation where the parties have made an express choice of law by deciding in the contract what law will govern the contract. And Rome I sets out rules that mean that if the parties have agreed that the contract will be governed by English law, then the courts of EU member states determining a dispute under that contract will be obliged to determine that dispute under English law rather than the law of their own jurisdiction. And vice versa, English courts determining disputes about contracts that contain French governing law clauses, for example, will continue to be bound to apply French law here to those contract disputes. The rules in Rome I also deal with the situation where the parties have not made a choice of law in the contract and have been silent as to what the governing law of the contract should be. And those rules are a bit complicated, but basically, and I'm summarizing here, there are a number of rules for different types of contracts. So if you have a supply contract, for example, then the Rome I says that the governing law of that contract will be the law of the jurisdiction in which the supplier is incorporated. Or if it's a distribution agreement, it will be the law where the distributor is incorporated. So those rules about how to determine the governing law, even where there isn't a choice of law, will also continue to apply after Brexit as well. Okay, Mark?
So the second issue, which will arise out of Brexit, it really concerns jurisdiction clauses within your agreements and then the ability to enforce. What I mean by jurisdiction is effectively, what court are you entitled to bring your claim? And by enforcement, what I mean is in what country will you be able to enforce any judgment that you obtain? And in the context of Brexit, this is a very complicated area. And actually, we're going to try and address this in more detail in our next contract conversations on the Tuesday, the 29th of September, where we'll focus specifically on dispute resolution clauses arising following post-Brexit and also in a post-COVID world. But in short, at the moment, as we all know, the UK is part of something called the Brussels recast regime. And what that effectively means is that if you prosecute a claim before a UK court and get a judgment, that judgment will be automatically recognised in Europe and vice versa in respect of European judgments. Post the end of the transition regime, the UK falls out of the Brussels recast regime and it therefore won't have the benefits of the Brussels recast regime. So what the UK has looked to do so far, it's looked to join something called the Lugano Convention, which operates similarly to Brussels, but has some limitations, which we'll discuss during our next contract conversations. But I think as many as you might have seen, the EU has already reported that it may seek to block the UK's accession to Lugano, in which case the UK will have to rely on something called the Hague Convention, which has some further limitations still. Such as the fact that it's only applicable to clauses where there's an exclusive jurisdiction clause. What we're seeing at the moment is that because of the uncertainty about dispute resolution clauses when dealing with European counterparties post the end of the transition period, is that parties are starting to consider arbitration as an alternative. And the reason why parties are considering arbitration, especially where they're dealing with EU counterparties, is because there's no such confusion there, because both the UK and the EU are part of something called the New York Convention, which again, we'll explain in more detail in the next contract conversations. But if you're looking at your contracts at the moment or are dealing with dispute resolution clauses, where you're dealing certainly with a European counterparty, you do need to think very carefully about how you're going to be able to enforce any judgment and whether the current DR or dispute resolution provisions that you have will provide you with the protection that you need.
Okay, data protection. During the transition period, the General Data Protection Regulation, the GDPR, continues to apply in the UK. Post-transition, we don't think there'll be much immediate impact on the framework as the GDPR will be transposed into UK law by UK legislation. However, organisations that transfer data between the European Economic Area and the UK may well need to put in place new or updated data transfer agreements. This is because in the event of a no-deal Brexit, the UK will become a third country under the GDPR, and in that case, controllers or processors of data that are based in the EEA will only be able to transfer data to the UK if certain conditions in the GDPR are met. And we think the conditions that are most likely to apply are firstly, either the EU Commission making an adequacy decision about the UK, deciding that the UK has adequate protections in place, or alternatively requiring that appropriate safeguards are put in place for EEA to UK transfers. So as we don't know at the moment if the EU Commission will make an adequacy decision in favour of the UK, the Information Commissioner's Office here has recommended that businesses use standard contractual clauses in order to put in place appropriate safeguards. And the ICO has published some suggested clauses on their website. So if you're a business that is involved in transferring data between the EEA and the UK, then you may want to check out the suggested clauses that are on the Information Commissioner's Office and review your data transfer agreements.
The next issue that we're sort of seeing parties talking about at the moment and clients is agreements where there are territorial references to the EU, and whether, certainly post the end of the transitional period, whether that will include the UK. Again, agreements such as license agreements, agency agreements will tend to make reference to particular territories in which one party or both are permitted to exploit particular opportunities under the agreement. But it's a good question as to whether or not the UK will be included within a definition of the EU or EEA post the end of the transition period. And sort of our view at the moment, obviously it's untested, but it will likely depend on when agreements are entered into. Certainly if you're trying to interpret agreements that are entered into before the 31st of January 2020, it's likely that a court will assess that a reference to a territory of the EU includes the UK on the basis that the UK was part of the EU prior to the 31st of January 2020. But certainly as we get to the end of the transitional period and beyond, that is going to be less likely, and you'll then start to have to look at what the parties intended when entering into the agreement as to whether or not the UK was supposed to be covered by such a definition of the EU. So given that, I think our recommendation at the moment is if you're dealing with agreements where there is a territorial aspect to the agreement and you want to be clear that the UK is covered within that territory, then to review those provisions and to try and seek amendments where necessary. The next sort of issue that is commonly sort of coming up with queries at the moment is in the context of agreements where there are references to EU law. This obviously will create a challenge post the end of the transition period because EU law will cease to directly apply in the UK post-transition. So questions arise as to whether references to EU law will include sort of implementing legislation or successor legislation in the UK going forward. And that position is unclear at the moment. I think realistically, the lack of clarity in this area is probably most pronounced in areas where the EU has imposed significant regulatory measures, such as financial services, and where parties have warranted that they'll comply with EU rules. But again, if you're dealing with contracts at the moment that make reference to EU law, it's a good idea at the moment to look at those agreements again and to try and seek amendments to those provisions in order to try and address those issues before the end of the transitional period.
Okay, agency. We don't think Brexit will have much impact on commercial agency agreements. Most agency principles derive from the English common law in this country rather than EU legislation or even UK legislation. There is, however, one relevant piece of EU intervention which has been enacted here via the Commercial Agents Council Directive Regulations 1993, which give commercial agents increased protection in a couple of different ways. So it gives the right for agents to be given notice of a certain period before an agency agreement can be terminated. And it also provides for compensation for commercial agents in certain circumstances if their commercial agencies are terminated. But under the withdrawal agreement, the UK government has agreed that those regulations will remain in force after Brexit, albeit on a different constitutional basis, and that commercial agents will therefore continue to be protected in those ways under the regulations. But after the immediate aftermath of Brexit has settled, we think it's possible that the government may be pressured into withdrawing the commercial agents regulations in favour of more free market policies, which would inevitably contain less regulation. So if you are an agent and a commercial agent and you're concerned about the possibility of losing rights that are guaranteed to you under the regulations, it may be prudent to negotiate for those rights to be expressly included in your contract with your principal, or at least to try to do that going forwards in any future agency agreements that you enter into in the future.
2P. I appreciate that most of the people on the call will be aware of what 2P is, but obviously it's a mechanism to protect the transfer of employees if the business in which they're employed changes hands. In respect of commercial agreements, they're most often in agreements such as outsourcing agreements, whereby employees will be transferred from the customer to the supplier at the start of agreement and then back at the end. I think, as we all know, 2P obviously it originates from EU law, and whilst that is the case, that I think generally it is unlikely that Brexit will have much effect on 2P, as the provisions are entrenched in current employment practices. In any event, I think this general perception in the market actually 2P is helpful for businesses and is incorporated in price into many commercial outsourcing arrangements for that basis. There does remain a chance, however, that post the end of the transition period and going forward, the government may try to use Brexit as an opportunity to try and tweak 2P in order to try and make it a little bit more business friendly. For example, I think one expectation we may have going forward is that the government may try and tweak that to make it easier for employers to harmonise employment terms once a transfer has occurred. But it's very much watch this space at the moment to see what legislative amendments are made to 2P effective provisions.
Okay, Brexit as a way of terminating contracts. Well, Brexit seems likely to have a big effect on the profitability of large numbers of contracts. We're going to have things like fluctuations in exchange rates, possibly tariffs being imposed, customs checks, and there's likely to be some effects on the labour market as well, all of which could cause financial hardship to one or other parties to a commercial contract, or even both parties. But the starting point under English law is that the courts will hold the parties to their bargain, even if that bargain turns out to be a bad one. There are only limited exceptions to that principle, such as where you can argue that a force majeure clause applies, or that the contract has been frustrated because it's become somehow impossible to perform the contract. But financial hardship on its own is unlikely to be enough to persuade an English court to allow you to terminate a contract. And there's a recent case from last year called Canary Wharf and the European Medicines Agency, which is a bit of an example of that. In that case, the High Court rejected the European Medicine Agency's argument that they should be able to terminate their 25-year lease of a premises in Canary Wharf because they said the contract had been frustrated by the UK's withdrawal from the European Union. But the court held that the lease would not be frustrated, as Brexit did not legally frustrate the contract. It didn't make it impossible for them to continue to lease those premises. It just made it no longer convenient for them to have their headquarters in the UK outside of the European Union. So that's an example of an argument that Brexit should allow you to get out of your contract failing, and we think that decision in particular is likely to deter others from claiming that their contracts have been frustrated by Brexit.
Okay, that's the end of the session. Just dealing with questions. Eric, do you want to take that one?
Have there been, we've got one question here. Have there been any examples of a contract being frustrated by Brexit? No, not that I'm aware of. The only example we're aware of somebody arguing that they're entitled to terminate a contract because it's been frustrated because of Brexit is that one that I just gave there of Canary Wharf and European Medicines Agency, which was a High Court case decided last year. And in that case, the argument failed. So we're not aware of a single example of anybody being able to get out of a contract on the grounds that it's been frustrated because of Brexit.
Okay. I think that So there's is this webinar repeated? There will be recordings of the webinar, which will be emailed to you shortly, together with a short article regarding some of the issues that we've discussed today. The aim of this series is to very much keep these as bite-sized webinars, 15 to 20 minutes, just so that you get the information which you need, but it doesn't eat too much into your day. Obviously, we're now at sort of 20 past, so we'll finish there due to time constraints. But if you've got any further questions, then please do get in touch. Equally, if there are any particular contractual topics that you'd like us to cover in this series, then please also do get in touch with us, either via LinkedIn or through our email addresses, which are available on the website. We'd be very grateful if you would just provide some feedback regarding your thoughts on this session today, just by answering the quick poll, which I understand will be on your screen shortly. The next contract conversation within the series, again, that's going to be on Tuesday, the 29th of September at 3 p.m, where we'll cover dispute resolution clauses in light of Brexit and COVID-19. Thank you very much for your time today, and I hope you have a pleasant afternoon. Thank you very much.
Thank you very much. Thanks for joining, everybody. See you next time.